I hate to say this, but this does not end here. This mess with the jury is a disaster. After more than 30 days of contentious trial that left no love lost between the parties, both sides have now rested in the retrial of a Massachusetts woman the prosecutors claim murdered her police officer boyfriend. Plus, a Manhattan jury returns a mixed verdict and potentially more serious problems in the trial of a Hollywood executive accused of multiple counts of assault. And another high-profile and powerful man hears the testimony of a former partner who now claims to have suffered years of abuse at the hands of the once powerful hip-hop mogul. All this and more this week on Courtroom Confidential. A few of the cases that we have been following closely are coming to their conclusion this week. A lot for us to discuss. We are recording this episode on Friday, June 13th, 2025, and this is your Courtroom Confidential Weekly Roundup. Let's jump in. Over a month since it began, both sides have now rested in the high-profile retrial of Massachusetts woman Karen Reed, accused of killing her boyfriend, Boston police officer John O'Keefe. Highly anticipated defense expert Andrew Rentschler, a biomechanical engineer with ARCA, was the last witness to take the stand, opining that O'Keefe's injuries were inconsistent with being struck by Reed's SUV. Rentschler argued that the level of force required to break the vehicle's taillight would have resulted in significant trauma, like broken bones, which were not found in O'Keefe's x-rays. At this speed, we're talking 4,000 pounds of force on the forearm, and with the hand, probably 1,400 to 3,000 pounds, Rentschler said, adding, well, above levels where you would get fractures. Under cross-examination, Special Prosecutor Hank Brennan pressed Rentschler about his ties to the defense, pointing out that he had lunch with the team during the first trial. Rentschler replied that he only stood in the corner and ate a ham sandwich. Once the defense rested, in a move that surprised many, the prosecution opted not to call any rebuttal witnesses, ending courtroom testimony. Judge Beverly Cannoni will meet with attorneys Thursday to finalize jury instructions. Closing arguments are set for Friday, with jury deliberations to follow. Reed is charged with second-degree murder and related offenses in O'Keefe's 2022 death. Prosecutors allege that Reed hit O'Keefe with her SUV during a snowstorm on January 29th of 2022 following a night of drinking. Her first trial ended with a hung jury. Speaking to reporters outside the courthouse, Reed said she's feeling anxious but believes the defense presented a stronger case this time. We just pulled more witnesses and laid out more of the case, she said. What's happening here? I think, if you're being honest, both sides deserve praise in how this case was litigated. It was a real showcase in talented, zealous, and tenacious attorneys. You are really seeing the best of the best battle it out in this case. And I also think strategy-wise, beyond the talent of the attorneys, but strategy-wise, you also saw some very smart decision-making in how this case was presented by both sides. From the prosecution perspective, this case was far more streamlined than it was the first time around. We have the benefit of being able to compare this case to the first trial. And just in that comparison, we see half as many witnesses called this time around. Less witnesses that did not move the ball forward. Not every witness who happens to have some little role in a case needs to be called at trial. When investigators investigate a case, they speak to everyone. That does not mean that everyone needs to end up on your witness list. Everyone who ends up on your witness list should be someone who moves the ball forward, someone who helps fill out the picture, complete the puzzle for the jurors. This time around, they were much smarter, used more discretion about who qualified for that. Each one of the witnesses called were people who I felt helped further the prosecution's theory of this case. It was less about combating the defense case preemptively. In fact, to the point that we heard from really no one, aside from one or two witnesses, from people who were inside of that home. The first trial, we heard from everyone that seemed to be even tangentially involved with what took place that evening. This time around, it was only the people who helped further the prosecution theory of the case. Same goes for the defense, though. The defense was far more streamlined. The defense focused less on this elaborate cover-up and conspiracy and got more to the heart of their theory of the case, the idea that they believe the Commonwealth cannot prove that John O'Keefe was hit by a vehicle. That is the entire heart of the case. In the defense's perspective, and this is true, if the prosecution cannot prove this, it is true that the entire case can rise or fall on that one issue. You don't need to get to the ideas of intoxication or intent if you can't even prove that John O'Keefe was hit by a vehicle. So in their view, the better question to answer is that they don't need to. They are not obligated to then tell the jurors what did happen. They just have to tell the jurors what didn't happen. As long as the jurors do not believe or do not have enough evidence to believe that John O'Keefe was hit by a vehicle, it's not on the defense to then supply them with the alternative. If the prosecution wants to close down alternatives, let them have it. But it's not on the defense to then say, well, he wasn't hit by a vehicle, but we will tell you what happened. And I think they concentrated too much on that idea the first time around. They've streamlined their case this time around, and I think to greater effect. Now, we're getting to closing arguments. And the question is, what will, or rather, what should both sides focus on in this case? For the defense, I think you have to zero in on those experts. The experts are where the defense was strongest. They want the jurors going back there not knowing which experts to believe. If they wanted to believe the defense experts, fantastic. But if they end up not knowing which experts to believe, also fantastic, because guess what we call that, folks? We call that reasonable doubt. If the jurors cannot, through these experts, come to a consensus as to what happened, specifically that question, was John O'Keefe hit by Karen Reed's vehicle, then that's reasonable doubt. So they want them talking about the experts. They want them confused by these experts. I'm not saying they were trying to confuse them, but they want them not knowing beyond a reasonable doubt what took place based upon the expert testimony, the reconstruction experts, the medical injury experts, even the dog bite experts all posed questions and gave opinions that they are hoping the jurors are talking about and nothing else when they get back in that deliberation room. Now, if you're the prosecution, you're hoping that they're considering everything else. Sure, the experts may have been helpful. Sure, the experts for the prosecution, you could argue, gave them some answers and presented some theories and gave them the idea that, yes, at least the prosecution theory is possible. It cannot be excluded. But really, if you're the prosecution, you don't want them talking about the experts. You want them talking about taillight fragments and debris fields and intoxication and Karen Reed's statements. Above all else, her statements. They have significant evidence on both sides to support their theories. But one thing I did not really hear the defense address was Karen Reed's statements. I'm talking about statements that she made to witnesses, to first responders, the morning John O'Keefe's body was discovered. I hit him, I hit him, I hit him. I'm talking about statements she made to the media, multiple interviews that she gave to different media outlets in interviews and documentaries. Statements like, he didn't look mortally wounded to me. Statements like, could I have clipped him? Statements like, I didn't think I hit him. If the jurors come back with any kind of conviction in this case, in my view, what really will have been, in my view, the final nail that sealed Karen Reed's fate will be Karen Reed's own words. But what do you guys think? What do you think is the most important evidence in this case? Please let us know in the comments. Harvey Weinstein has been found guilty on one count of committing a criminal sexual act in his New York retrial, while being acquitted on a second and a mistrial being declared on a third. On Wednesday, the Manhattan jury, composed mostly of women, convicted the once powerful movie mogul of sexually assaulting Miriam Haley, a former production assistant. However, Weinstein avoided conviction on a similar charge involving Polish model Kaja Sokola, and jurors could not reach a unanimous decision on the third count related to actress Jessica Mann. Weinstein, who has long denied the allegations, addressed the court before the partial verdict was read, calling the trial unfair and urging the judge to declare a mistrial as several jurors reported ongoing tensions in the deliberation room. Quote, "This is my life that's on the line," Weinstein told Judge Curtis Farber, adding, "I'm not getting a fair trial." Weinstein then told the judge, "You are endangering me, Your Honor." Earlier in the day, the jury foreperson reported intense disagreements and requested a private meeting with the judge and attorneys to discuss the situation. Later in court, Farber conveyed the foreperson's account, stating that there was infighting among the jurors and that the foreperson was, quote, "not going to change his position, whatever that position is." The foreperson reported yelling and screaming amongst jurors, and at least one allegedly saying, "I'll meet you outside one day." Quote, "A crime was committed against this juror," Weinstein's lawyer Arthur Aidala argued, describing the situation in the deliberation room as menacing and harassment. Aidala added, "Their verdict is all about coercion and threats." On Thursday morning, the judge finally declared a mistrial on the undecided third count after the same jury foreperson refused to rejoin the deliberations. Weinstein faced 3 charges, 2 counts of criminal sexual act in the first degree and 1 count of third-degree rape. The retrial stems from a 2020 conviction that was overturned in April after New York's highest court ruled he was unfairly tried with uncharged crimes. Outside court, Haley told reporters, quote, "I just want to say that I'm so grateful to the jury," and called out the defense's disruptive and chaotic tone, adding, "Testifying in the face of constant disruptions, victim shaming, and deliberate attempts to distort the truth was exhausting and at times dehumanizing. But today's verdict gives me hope. Hope there is new awareness around sexual violence and that the myth of the perfect victim is fading." Prosecutors vowed to try Weinstein again on the third deadlock charge. No formal announcement has been made. Weinstein continues to serve a separate 16-year sentence from his 2022 conviction in Los Angeles. What's happening here? I hate to say this, but this does not end here. This mess with the jury is a disaster. Rarely do we get this kind of insight into what the jurors were thinking or doing back in the deliberation room. Usually that is all a mystery and all kept entirely inside the 4 corners of that room. And maybe, if anything, we learn about it after the fact, after a verdict in some tell-all book down the road. Rarely do we have a juror coming forward and saying, "The situation back there is awful, is this bad." What is being alluded to here? Coercion, threats, consideration of outside evidence? Mark my words, this will be appealed. There is no doubt in my mind. And if Weinstein's attorneys are able to talk to these jurors, are able to get some of them on the record, they have a real shot at appeal here. This is exactly the kind of stuff we hope to avoid in deliberations. Consideration of outside evidence, the character of the defendant, jurors threatening each other, jurors refusing to deliberate. They might win this appeal if they're able to get that evidence in front of a court of appeal. This is very disappointing. I am not trying to be sensationalist here. As a prosecutor, I remember feeling sick to my stomach when you would hear jurors speaking outside the courtroom. And some of the things they would start to say, you would wonder, oh my, is this going to be something that haunts me later on down the line? But never in all my years did it become even close to anything like we're hearing here. The one saving grace in all of this is that it was a mixed verdict. The idea that they found him guilty on one charge, not guilty on another, or hung on another charge, that to me shows contemplation, shows deliberation, shows a jury that despite all the fighting was coming to agreement on some things, and their agreement was not necessarily the same on every single charge. So perhaps at the end of the day, that might save this case. But does the defense view this as a win? I think you have to be honest and say yes. You have to admit that where he was just a couple of years ago, convicted of multiple counts, looking to spend years in prison, and now one of those counts he's been acquitted of, Another count was deadlocked. Perhaps they'll try to retry it. One count he's convicted on now, his exposure is far less, and even that may be subject to some sort of appeal down the road. I think you have to admit that he's in a far better position than he was. But what do you guys think? Do you think I've got it all wrong, or do you think that the jury's conduct as described could be a disaster for this case? Please let us know in the comments. The ongoing federal trial of hip-hop mogul Sean Diddy Combs entered its 5th week of testimony, with an ex-girlfriend testifying under the pseudonym Jane finishing direct examination. Jane alleged that Combs maintained control over her housing, finances, and legal representation well into 2024, even after they tried to end the relationship. At one point, she described a violent altercation after confronting Combs about being with another woman on a trip. She pushed his head into a marble counter and threw candles. He responded by kicking her, choking her, and escalating the fight physically. Afterward, Combs told her to cover her injuries with makeup and take ecstasy because an entertainer, their term for a male prostitute, was coming over. When she resisted, he got close and said, "Is this coercion?" She testified that she ultimately had sex with the entertainer while Combs watched. After federal raids on Combs' properties, Jane testified she received a business card from Homeland Security Investigations. Combs then hired her current lawyer, whose services he continues to pay for to this day. Despite everything, Jane said she remained in contact with Combs up to his arrest, last seeing him in August of 2024. During cross-examination, Jane admitted she agreed to sexual encounters with other men because she believed it was the only way to see Combs. Jurors also saw texts where Jane expressed frustration that Combs pressured her for a hotel night when he was spending time with another woman. She admitted it bothered her that others received gifts and trips while she did not receive the same treatment, even when she agreed to have sex with strangers. In other text messages, Jane expressed deep affection for Combs. After one hotel night in 2022, she texted, "My love for you is unconditional and for life." In 2023, around the time she moved into a home Combs still pays for, she wrote, "I love you so much as my friend, my lover, my boyfriend, even though you don't like that word." Jane said there was roughly a 2-month break in hotel nights, what has previously in the trial been referred to as freak-offs, from April to late June 2023, though they still spent time together. During that period, when Combs asked about arranging a hotel night, Jane replied, "Not really in the mood for that part, don't want to make you mad." Combs responded, "All good." Jane testified she was hurt after being made to have sex with 3 guys. They broke up for several weeks until Combs planned a trip to Turks and Caicos for him and Jane. Remember, Jane previously testified this was a trip meant to connect them and that she's told Combs, "I just want us," but it ended up featuring a hotel night with an entertainer. Jane's cross-examination is expected to continue through Thursday morning. What's happening here? If this all sounds messy and less than clear-cut, that is because it absolutely is. But the question is that a fatal problem for the prosecution? Domestic violence cases, sexual abuse cases are messy cases. Their behavior and the way they play out are rarely clear-cut. There is rarely black and white distinction between the conduct of everyone involved. But the problem is, will the jury be able to understand and appreciate all that? The fact that this witness admits that she did things willingly is a very bad fact for the prosecution. The fact that she talks about times that she didn't want to do something and Combs appeared to respect that is a very bad fact for the prosecution. Now, that does not mean that other conduct could not be without consent, that other acts of violence are not crimes, that other times that he forced her to do things, she explained that that was without her consent and understood she was doing it without her consent. But it does call into question the reasonableness of her conduct. More importantly, it calls into question how a reasonable person in Sean Combs' position would have perceived her conduct. And therein lies the problem. Consent is all about what we call a reasonable person standard. But that is not from the point of view or perspective of the victim, but from the point of view of the defendant? What would a reasonable person in Sean Diddy Combs' shoes have perceived by the words and actions of Jane? And we're talking about somebody doing something more than reluctantly, more than begrudgingly, but acquiescing to it. We're talking about someone doing something against their will, through fear, through force, through coercion, and that can be perceived by a reasonable bystander, not perceived only as existing in the inner workings of that person's head. But what do you guys think? Do you think that there is absolutely enough here to show lack of consent? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask that you just take a moment and do me one very small favor, and that is, if you have not already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. And please don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, after less than an hour of deliberations, an Arizona jury has found the notorious Doomsday Mom guilty of plotting the 2019 shooting of her former nephew-in-law. Lori Vallow Daybell, who opted to again represent herself, rested her case Wednesday without calling any witnesses. Prosecutors allege that Vallow Daybell conspired with her brother Alex Cox to kill Brandon Boudreaux because she believed he had accessed her computer. Boudreaux was unharmed in the shooting, which took place in 2019 outside his Gilbert, Arizona rental home when a bullet shattered his car window and narrowly missed his head. The trial began last week after a 2-day delay due to Vallow Daybell's reported illness. The following day, she was briefly removed from court after arguing with the judge. This marks Vallow Daybell's third conviction. She was found guilty in May of 2023 of the murders of her children, JJ Vallow and Tylee Ryan, and her husband, Chad Daybell's first wife, Tammy Daybell. In April of this year, she was convicted in Arizona for conspiring to murder her fourth husband, Charles Vallow. Sentencing is scheduled for July 25th. The Florida matriarch, who authorities believe masterminded the death of her son-in-law, has been ordered to transfer jail facilities. Donna Adelson has been transferred from Leon County to the Wakulla County Detention Facility following a policy change that cut off her access to a jail-issued tablet, something her lawyers say she relied on to communicate with them daily. Adelson faces charges of first-degree murder, conspiracy, and solicitation in the 2014 killing of her former son-in-law, Florida State law professor Dan Markell. A spokesperson for the Leon County Sheriff's Office said the decision came after her attorney requested the transfer, prompted by the new policy restricting tablet use for inmates in administrative custody. Previously, inmates were allowed tablets in their cells. Once that access was revoked, Adelson's team contacted officials in Wakulla County to see if she could be housed there. Adelson's attorney, Josh Zellman, said that she had been using the tablet to make phone calls to her legal team 3 times a day, 7 days a week, in preparation for trial. He noted that the transfer did not require court intervention. Adelson has repeatedly raised concerns about her treatment behind bars, alleging cruel and unusual punishment and incidents of blackmail and unwanted touching. More recently, a jailhouse informant accused her of offering to pay for favorable witness testimony, an allegation that delayed her trial. No charges have been filed. Jury selection in Adelson's case is currently scheduled to begin August 19th. The Utah Supreme Court has declined to hear an appeal from a mother and children's writer, effectively confirming that her murder trial will remain in and be heard by a Summit County jury. Kouri Richins, a former real estate agent, is accused of fatally poisoning her husband, Eric Richins, in 2022. She would go on to write a children's book about grieving him and was arrested in 2023 in connection with his death. Richins faces 9 felony charges, including aggravated murder and financial crimes. Her defense team had asked for a Salt Lake County jury to hear her case, citing concerns about extensive pretrial publicity making it impossible to seat an impartial jury locally. Nevertheless, in a June 6th ruling, the High Court upheld a previous decision by District Judge Richard Mrazek, who had denied the venue change. This marks the second time the Utah Supreme Court has denied jury-related appeals. In February, February, it rejected a joint request by prosecutors and defense attorneys to select jurors in person instead of over video. Richins' attorney responded to the latest decision in a June 10th statement. Quote, "We remain concerned that the extensive negative publicity that has plagued Summit County since the beginning of this case has left potential jurors with false impressions of the facts in this case. We are confident that when the jury is ultimately selected and hears the true facts and gets to know the kind of wife, mother, and person Kouri is, that they will believe in her innocence as much as we do." The trial was originally set for May, but was postponed indefinitely to allow for appeals. Following the latest ruling, prosecutors asked the district court to resume scheduling. A major setback was suffered by one of the Hollywood stars at the center of a highly contentious and publicized defamation lawsuit. On Monday, a judge dismissed Justin Baldoni's $400 million lawsuit against Blake Lively and Ryan Reynolds, marking a major development in the civil battle between former co-stars Lively and Baldoni. Baldoni filed the suit in January, accusing the couple of trying to destroy him and hijack his film It Ends With Us, which he directed and co-starred in with Lively. The legal clash began last December after Lively filed a civil rights complaint against Baldoni of sexual harassment during filming and retaliation for speaking out. Baldoni denied the claims. Lively later filed a formal lawsuit against Baldoni. In a statement posted on her Instagram account, Lively wrote, quote, "Like so many others, I've felt the pain of a retaliatory lawsuit, including the manufactured shame that tries to break us. While the suit against me was defeated, so many don't have the resources to fight back. I'm more resolved than ever to continue to stand for every woman's right to have a voice in protecting themselves, including their safety, their integrity, their dignity, and their story." Motions to dismiss by Lively, Reynolds, their publicist Leslie Sloan, and the New York Times, which Baldoni sued for $250 million over its reporting, were all granted. In a statement on Tuesday, Justin Baldoni's attorney Brian Friedman confirmed their intention to amend the lawsuit against Blake Lively, emphasizing that the court has allowed them to revise 4 of the 7 claims. This case is about false accusations of sexual harassment and retaliation and a non-existent smear campaign. With the facts on our side, we march forward with the same confidence that we had when Ms. Lively and her cohorts initiated this battle and look forward to her forthcoming deposition. Meanwhile, the New York Times responded to the court's dismissal of Baldoni's $250 million libel suit against the publication. Spokesperson Charlie Statlander said, "We're grateful to the court for seeing the lawsuit for what it was, a meritless attempt to stifle honest reporting." Defending the outlet's article titled, "We Can Bury Anyone Inside a Hollywood Smear Machine." The piece broke the news that Lively had filed a civil rights complaint over Baldoni's alleged on-set conduct during filming. The judge's ruling on Monday did not address the merits of Baldoni's complaint, but rather held that Lively's sexual harassment claims in her complaint were protected by law and could not form the basis of a defamation claim, citing California's legal protections for survivors who come forward, a safeguard rooted in the Me Too era legislation. Although the court has not ruled on the underlying merits of either party's claims, the legal fight continues to draw public scrutiny. In February, Baldoni's team launched a website aimed at discrediting Lively's accusations by sharing text messages and an alleged timeline. A leaked voice note and multiple media statements from Baldoni's lawyer have been debated in court. Their trial has been set for March 9th, 2026. Nearly 4 years after a man's body was found wrapped in a tarp and dumped in South Carolina's Little PD River, his ex-girlfriend is on trial for his murder. Meagan Jackson, the mother of Gregory Rice's 4 children and a former coroner's body transporter, is accused of conspiring with her then-lover, former Deputy Coroner Christopher Dontel, to kill Rice. The pair were having an affair at the time, and both were initially charged with murder, conspiring to commit murder, and kidnapping. Rice was last seen on October 2nd of 2020. Jackson reported him missing 3 days later. His body was found over a month later by a fisherman, shot 5 times, wrapped in a tarp, zip-tied, and weighed down with a cinder block. Dontel avoided trial by pleading guilty to conspiracy and accessory after the fact, agreeing to testify against Jackson in exchange for the dismissal of the murder charge. Surveillance video showed him buying the tarp, zip ties, and cement blocks used to dispose of the body. Investigators also relied on cell phone data and license plate readers to build their case. At the time of the killing, Jackson was pregnant with Dontel's child. Both worked in the death care industry, transporting human remains for local funeral homes and the coroner's office. Dontel will be sentenced after Jackson's trial, facing up to 15 years in prison for conspiracy and 5 years for accessory. During opening statements on Tuesday, Assistant Solicitor Lee Waller described Jackson as a master manipulator who lured the father of her children to his death and then manipulated law enforcement and her lover to cover her tracks. Defense attorney Case Britton told jurors that he expected co-defendant Chris Dontel to point the finger at his client after pleading guilty to conspiracy to avoid a murder charge. He noted that Dontel had everything to lose by his affair with Jackson, while his client had no motive, having ended her relationship with the victim. Savannah Rice, the daughter of Jackson and Rice, testified Tuesday that her parents fought often and lacked a loving relationship. She said her father was flawed but cared deeply for his children. Savannah recalled that her parents had broken up twice before and that she never heard them say, "I love you," to each other. Before her father's body was found, Savannah testified that Jackson once came home drunk and said, "I hope what happened to your father happens to your sister." Trial is ongoing. Attorneys for a former Lecter County, Kentucky sheriff accused of fatally shooting a district judge in his courthouse chambers have filed a motion to dismiss the indictment against him. Sean Mickey Steins and his defense team argued the state failed to record a November 2024 meeting before prosecutors and the grand jury that indicted the former sheriff for the murder of Judge Kevin Mullins. According to the motion, the grand jury was not told about an ongoing civil lawsuit in which Steins is a defendant. Information his lawyers say could provide crucial context for the September 19th shooting, which was captured on courthouse surveillance video. Both Steins and Mullins were prominent figures in the community for decades. Steins had been deposed just 3 days before the shooting in a civil rights case involving his former deputy, Ben Fields, who is now serving time for raping a woman inside the courthouse. That victim was on home confinement at the time, and Fields allegedly offered to remove her ankle monitor in exchange for sex. Bartley told reporters that Steins feared for the safety of his wife and daughter and believed they were in danger because of what he knew about misconduct inside the courthouse. There was pressure. There were threats made to him to sort of keep him in line, to keep him from saying more than these folks wanted him to say, Bartley said. Body camera footage from the scene shows a paranoid and distraught Steins pleading with officers saying, "Come on, be fair to me now. I seen the look. Y'all come on now. Don't kill me. Don't punish me. You know, let's be fair. Don't shoot me." Nothing like that. "Y'all are gonna kill me, aren't you?" he continues. "Y'all are gonna kill me. I know you are. Let's just get it over with. Let's just go." Bartley is planning an insanity defense. Before we get to what's on the docket for next week, I just wanted to take a moment to thank you all for being a part of our growing Courtroom Confidential community. But I wanted to give a special shout out to Z Poodle for their kind review on Apple Podcasts, as well as to our CC crew members, Tamantha Jane and Lori6332 for their support on YouTube. Please keep them coming. We absolutely love hearing from you, and please tell us where you're from. We are thrilled by the growth of our Courtroom Confidential community. On the docket for next week, James Craig, a former Colorado dentist accused of poisoning his wife Angela in 2023 and allegedly trying to get a fellow inmate to kill a detective investigating the murder, will return to court on Monday, June 16th for a motions hearing. Reed Galinsky, 15-year-old Wisconsin teen charged with killing his mother after allegedly being inspired by a Menendez Brothers documentary, is due back in court Monday, June 16th. Colin Gray, the Georgia father who faces charges of second-degree murder and second-degree cruelty to children for allegedly allowing his teenage son, Colt Gray, access to the AR-15-style rifle used in the 2024 mass shooting at Appalachia High School, will return to court on Tuesday, June 17th. Gregory Moore, the Ohio divorce attorney accused of killing his client, Cleveland Clinic nurse Eliza Sherman, more than a decade ago, will be in court for a pretrial hearing on Tuesday, June 17th. Henry Tenon, the confessed gunman allegedly hired by Shanna Gardner in the murder-for-hire shooting death of her ex-husband Jared Bridegan, will be back in a Florida court on Tuesday, June 17th. Accused Gilgo Beach serial killer Rex Heuermann will return to court on Tuesday, June 17th, as the judge continues to weigh whether to allow key DNA evidence into the trial. Bianca Ellis, the Ohio woman accused of fatally stabbing a 3-year-old in a grocery store parking lot in 2024, will return to court on Wednesday, June 18th for a pretrial hearing. Brian Kohberger, charged in the killings of 4 University of Idaho students in 2022, will be back in court Wednesday, June 18th for a hearing on a motion to continue and a third-party perpetrator evidence hearing. And finally, please join us on YouTube this Sunday for our special question and answer series, Sunday Fun Day. All are invited to leave us a voice message at thecourtroomconfidential.com, which we will answer during tomorrow's live stream at 9 a.m. Pacific, noon Eastern. That's it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.